To file for divorce in North Carolina, you need two things. You and your spouse must have lived separate and apart for at least 1 year and 1 day, and one of you must have lived in North Carolina for at least 6 months. Meet those two and you are entitled to the divorce. Here is the whole process, step by step, including the 2 deadline traps that catch people who try to do this alone. North Carolina is a no-fault divorce state. You don't have to prove your spouse did anything wrong, and you don't need their permission or their signature. There are only 2 requirements. First, residency. You or your spouse must have lived in North Carolina for at least 6 months right before you file. Residency means physical presence plus the intent to stay, and things like a North Carolina driver's license, voter registration, tax filings, and utility bills all help show it. You don't have to be a U.S. citizen, and students can qualify. Second, 1 year of separation. You and your spouse must have lived separate and apart in separate residences for at least a year, and at least one of you must have intended when the separation began that it be permanent. Separate bedrooms under the same roof do not count, and if you move back in together or resume the marital relationship during that year, the clock generally restarts. This next point confuses almost everyone, so we want to be precise about it. There's no such thing as filing for legal separation in North Carolina. You do not submit paperwork to become separated. Separation is a factual state. It begins the day you and your spouse start living in separate homes with the intent by at least one of you to stay apart. That's it. The calendar and your living arrangement are what make you separated. Many couples do sign a separation agreement during that year to settle property, support, and custody, and that is often a wise move. But the agreement is not what makes you separated. We've linked our guide to separation agreements and to legal separation in North Carolina below this video. Here's the part that surprises people in a good way. That 1 year wait applies only to the absolute divorce itself, the court judgment that legally ends your marriage. Almost everything else can be handled during the separation year. Child custody and child support can be filed for as soon as you separate. You do not wait for the divorce. A dependent spouse can ask the court for post-separation support, which is temporary spousal support while the case is pending. And marital property can be divided anytime after separation, either by asking the court for what's called equitable distribution, or by resolving it yourselves in a separation agreement. In North Carolina, these are legally separate claims from the divorce. Hold on to that, because it creates the single most important trap in the whole process, and we'll get to it in a few minutes. The standard packet for an absolute divorce is 4 documents. A complaint for absolute divorce, which opens the case and states the facts, marriage date, separation date, residency. You'll sometimes hear people say divorce petition, but North Carolina calls it a complaint, and the person filing is the plaintiff. A civil summons, the official notice telling your spouse a lawsuit has been filed and that they have a limited time to respond. A domestic civil action cover sheet, an administrative form the clerk uses to route your case, and an affidavit about whether your spouse is on active military duty, because federal law gives service members special protections before a court can move forward. You file all of it with the clerk of court in the county where either you or your spouse lives. If you want your former name back, you can ask for that right in the divorce at no extra cost. It is much simpler than doing it later. Filing is not enough. Your spouse has to receive formal legal notice, which the courts call service of process. Under the North Carolina Rules of Civil Procedure, you generally have 4 options. The sheriff in your spouse's county can personally deliver the summons and complaint. You can use certified mail, return receipt requested, and file the signed green card with an affidavit as proof. You can use a designated delivery service like FedEx or UPS with a signature and proof of delivery filed with the court. And if you genuinely cannot locate your spouse after a diligent effort, there is service by publication, running a notice in a qualifying newspaper. That's the last resort. It is slower, and it carries a property division wrinkle we cover in our Absolute Divorce Guide, linked below. Once your spouse is served, they have a limited window to file an answer. If that deadline passes with no response, you can move the case forward without them. For most families, the road looks like this, and most of it happens outside a courtroom. Your spouse responds or doesn't. A divorce based on 1 year's separation is essentially impossible to block. Your spouse cannot stop it by refusing to answer or refusing to agree. The connected issues get worked out. Custody, support, and property are resolved by agreement whenever possible through direct negotiation, mediation, or the collaborative process. If you already signed a separation agreement, much of that is done. Contested issues may involve discovery, the formal exchange of financial documents and information, then the divorce itself is granted. In an uncontested case, many counties let the judge grant it on the paperwork alone, meaning you may never set foot in a courtroom. Otherwise, there's a short hearing with a handful of routine questions. Finally, the judge signs the divorce judgment. That's the document that legally ends the marriage. You are single again and free to remarry the day it is entered. The biggest mistake people make filing on their own is waiting too long to raise their money and property claims. Here it is plainly. Your rights to equitable distribution, which is property division, and to alimony are permanently lost if those claims are not pending, meaning filed with the court or resolved in a valid agreement before the judge signs the absolute divorce judgment. Read that twice because this is the trap that does the most damage. The moment the divorce is granted, an unasserted property or alimony claim is gone, not postponed, gone. A spouse who just wanted the divorce done and planned to sort out the house, the retirement accounts, and support later has, legally speaking, already sorted them out. They've waived them. Custody and child support are different. Those can always be raised or modified later because they belong to the child more than to the parents. But property and alimony have a hard deadline. If your spouse files for divorce and you have any potential property or support claim at all, talk to an attorney before that judgment is entered. Legally, no. Practically, it depends on what's at stake. If the marriage was short, there's no property to divide, no children, and no support issues, a careful person can often handle a simple absolute divorce. But if there's a house, retirement accounts, debt, children, or any income gap between the two of you, the filing itself is the easy part. It's the claims around the filing where people lose things they can never get back. At a minimum, spend one consultation making sure you are not walking straight past that deadline we just described. Filing for divorce is a series of small, manageable steps, but the order matters and two of the deadlines are unforgiving. At McCrary Pack, PLLC, we've walked thousands of neighbors through this exact process, and we'll tell you honestly which parts you can handle yourself and which parts deserve a professional's eyes. Family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. The full step-by-step guide, the current filing fee, and the forms are all on the page linked below. Reach out today, and let's talk through where you are.